All right, ladies and gentlemen, my name is Ramsay. I'm a judge or magistrate for Denton County. So just here to make sure you understand your rights, your charge, and your bond. These are recorded proceedings. They are actually, believe it or not, transmitted through YouTube. I don't know if anyone watches, but it is an open proceeding and it is recorded. So the reason I tell you that up front is you might want to avoid saying anything that might be incriminating, because it could come back to be used against you later on at court. But again, these are our magistrate arraignments for January 26, 2022. It's now about 12:30, and these are our morning arraignments, so we're way off schedule. But other than that, though, part of my job is just to explain rights, charge, and bond. Bond, of course, being the amount of money that you need to post with the court in certain cases, promise to pay in certain cases, as in a personal bond, or in other cases, the amount that you would need to post in cash or ask for a court to set in order to get out of jail prior to going to trial. You do have to post that money in full in cash if you have that kind of money, or you can if you have that kind of money, but most people don't. So they go through a bondsman. Bondsman charge percentages. Typically, a bondsman will charge you between 10 and 25% of the total amount that I tell you, but really kind of depends on whatever you can work out of the bondsman. Different bondsmen do charge different rates. So again, what I suggest you do, call a friend or family member, tell them you're in the Denton County Jail, how much bond's going to be, and then let them work on trying to get you out. Now, other than that, you certainly still have all your same constitutional rights. You have the right to remain silent. You do not have to talk to the police at all, because anything you say can and probably will be used against you later on. So again, you still want to be careful what you say. If you start to make a statement to the police or anyone representing the state, you can always stop at any time. You do not have to continue to talk. You have the right to speak with an attorney, have an attorney present or any question, have the attorney represent you in court in that trial. And if you cannot afford to hire your own attorney, Denton County will appoint or pay for an attorney for you, or if it's one from a different county, then that county will appoint and pay for an attorney for you, so long as you're truly indigent. Indigent means you don't have a job, source of income, family or friends, or any way by which you can pay for your own attorney, post your bond. So if you're sure that you're not going to get your bond posted, if you indicate that on this form here today, we're going to have you fill out an affidavit to request a court-appointed attorney. Just make sure that you fill out that affidavit completely and fully, showing that you are in fact too poor to afford an attorney. We'll send that information over to the county. The county and district court judges will review that information. If they agree with you and if they find you indigent, then Denton County will appoint or sign you a court-appointed attorney, although you typically won't be talking to a court-appointed attorney for another 2 or 3 days after date of appointment. But again, if you're claiming to be indigent, whether you're going to bond out or not, even if you do bond out, you can still ask for a court-appointed counsel. If you're here for a felony grade offense and you're unable to post your bond after a reasonable period of time, you can also ask the court to release you without posting bond at an examining trial. That's really kind of a legal process that more often applies only to felonies, only when you haven't been able to post your bond, and only when there's not been an indictment returned against you first. Last, but certainly most importantly, you absolutely still have the right to a trial by judge or jury. Just because you're charged and arrested doesn't mean you're guilty. You certainly do have a right to a trial, but you would need to post your bond in order to get out of jail prior to going to trial. So again, when I call your name, come on up front. There's going to be a white arraignment sheet on that judge's bench in front of you. You're going to ask that you sign it. By signing it, you're not saying you agree with it. You're just telling me you understand all your rights, your charges, and your bond. So let me get out of this document. Gregory Moore. Mr. Moore, come on up. Mr. Moore, they have you here on one charge of robbery, but it is a warrant out of the 462nd District Court. It's not a new case. In fact, it's an older case that you'd already posted a bond on. So the bond is at only gone up by a few dollars. It's at now at $30,017.16. So again, it's just where your bonds went off your bond, probably because you're arrested on some other charge, and that gives them the right to go off your bond. So you just have to post a new bond on the same case you already paid for once. So without saying you agree with it or admit guilt, just that you understand your rights, charge, and bond. Again, that's on warrant F20-1794367, which means it is filed in the 367th District Court. Let me get your signature on that form saying you understand rights, charge, and bond. And do you think that you'll be able to make arrangements for your own attorney, or do you have an attorney?
I currently have an attorney, court appointed.
Okay, is it Josh Healy?
No, sir. It was a female. I'm not even sure of her name, but I wanted to ask you a question, sir, if you don't mind, about my attorney that I do have on the case for the robbery, because I'm pretty sure I'm set to trial on the 7th of February.
I don't have the docket settings in front of me, but I'm showing your attorney to be Josh Healy. Who do you think your attorney is?
It's definitely a female. I met with her like in October. You know, I don't know if she threw herself off my case because we did have like words because she spoke on my case. I don't know who the prosecutor or the DA is. She spoke on my case in front of the prosecutor and the DA. So I had told her, I was like, I know I can take that to the bar or something. So I think she might have just jumped off my case because I haven't heard it. It's Crystal Ebonize.
Don't even know that name. Kristen Ebonias?
Crystal Lebonize.
Oh, Lavanius. Well, she's now a district judge. So yeah, she won't be your attorney. So it's Josh Healy now. Yeah, and obviously this case can't be filed in Judge Lavanius's court. So I guess that probably turned out well for you. So let me get your signature there. We'll notify Mr. Healy to come talk to you about this case as well. So let me get your signature on there, just saying you understand rights, charge, and bond. And then initials in the bottom box saying you're still asking for court-appointed counsel. And of course, your attorney needs to do what you ask him to do, but your attorney is supposed to talk to the court on your behalf, right?
Yes, sir. But no. Like me and her were discussing my situation of the case, and this wasn't in court. This was outside the courtroom upstairs.
Oh, okay.
So you feel me, sir?
I don't know.
Look, I was probably like 10 yards away from them, but I don't know them. I don't know that that's the prosecutor. I don't know that's the DA because the COVID been going on and I haven't stepped in the courtroom. So I didn't even know that those were the prosecutor or the DA. But she was speaking on my case, and then after she spoke on it, this is how I acknowledged that it was even then the prosecutor and the DA. She said, "Oh, my bad. That's the prosecutor right there." Like, what? Come on now. How was I even supposed to know that?
I don't know. Okay, we'll get Mr. Healy to come over here and talk to you. So you have a new attorney now. Okay.
Thank you, sir. Yeah.
All right. Thanks.
I got one more question, sir.
What's that?
Is there any way you can lower my bond because they just took $1,800 out of my pockets in
Your attorney can file a motion for reduction of bond, and your period of time in custody will be one of those considerations.
Okay.
And the fact that you turn yourself into law also will help.
Okay, I appreciate you, sir.
All right, thanks. Have a seat. Nicholas Sikic. Let's see, Nick, they have you here on charge of possession, controlled substance, pen group 1 under 1 gram amount. Not a new case, it's an old case, but now it's showing no bond because the judge of the 211 District Court, Judge Shanklin, indicates that you failed to appear for court. So it's possible to get bond set, but you would have to get Judge Shanklin to do that for you. So it's F21 2139 211, no bail currently, but hopefully Ms. Morgan could get bond set for you. So you have an attorney by the name of Gina Morgan. Have you talked to her about this case?
Yes, sir.
All right, so let me get your signature on that line saying you understand rights, charge, or bond, not saying you agree with it. And then initials in the bottom box saying you still need Ms. Morgan to come talk to you, and we'll notify her to come over here and see you, okay?
All right, thank you, sir.
Thank you. Laurel Goods. Mr. Goods, one charge of aggravated assault or two charges of aggravated assault out of the 211 District Court warrants F20 1276 431st and F20 1277 431st. No bond on either one, so it's possible to get bond set, but because they're probation violations, only the judge of the court in which the case is filed can do that for you. So they've been assigned to the 431st District Court. So if you have an attorney, I think you do, Mr. Lacey, is that correct?
Yeah, he already filed a motion of a bail or a bond on the 20th.
Okay, hopefully we'll hear back from that today. They have an electronic system for filing those, so maybe we'll see an order setting bond here soon, okay?
Okay, because I know it's like 72 hours that the courts have to communicate back with my lawyer? Because I turned myself in voluntarily.
Well, they try to, yes, but on a probation violation, some of the rules, those strict timelines don't necessarily apply, but he may have to get it set for a hearing, but contact Mr. Lacy, he can tell you what the status of it is. Yeah, probation violation is a little bit different. So let me get your signature on that form, just saying you understand rights charged. On this one, you don't have a right to a trial anymore, but you do have a right to a hearing to determine whether or not you actually violate your probation.
Okay,
And then hopefully we'll hear back from the court today or tomorrow, okay?
okay.
And then initials in that top box saying you're not indigent, you have your own attorney, you have Mr. Lacy. All right, thank you. Lori Shea.
Yes, sir.
Ms. Shea, one charge of driving while intoxicated. It's Denton County Sheriff's Office warrant, bonds at $20,000. So bonds run you maybe, $2,000, depends on the bonds. But the reason why it's so high, because it is still being charged as a misdemeanor charge, but they're showing 2 pending DWIs, one back from like 6 months ago, and one back from about 3 months ago. So bonds at $20,000 with an ignition lock system requires condition of bond. So without saying you agree with it either, just so you understand rights, charge, of bond, let me get your signature on that form, just saying you understand your rights, your charge, and your bond.
There's no way that I can get that reduced at all.
Yeah, you can, if you have an attorney that can file a request for a reduction of bond, we can get that set up and notify the district attorney's office so that we can get their input in on it.
I contact my attorney,
You-
or do y'all?
You should. Well, do you have an attorney already?
George Rowland is the court-appointed attorney.
He's a very good attorney, very caring man. So you can call him and see. We typically do appoint the same one. Is he on both your other cases as well?
Yes, sir. And I'm completely embarrassed. It's been over a year since anything, and I don't know what happened to me.
Yeah, we all have our demons. I think they come back in time. So talk to George, but in the meantime, we'll notify him. We'll get him appointed on this one as well. So let me get your signature there. You can still try to post. You can try to postpone today, but if you can't, talk to George and see if you can get this set for a reduction.
So do you contact him, or do I? Or
We will
both?
notify him that he's been. If you're claiming to be indigent, we're going to notify him. We'll go ahead and appoint today. So let's get your signature on that line and your initials in the bottom box saying you want us to contact Mr. Rowland on your behalf. All right, we'll get that started.
Your Honor, she has the conditions of bond, I believe.
Oh, I'm sorry. There is a requirement of ignition interlock system installed as a condition of your bond. Are you familiar with that device?
No.
It is a requirement that you have this device installed in your vehicle. It does have to be installed within 1 week. So you have 7 days to get the system installed in your vehicle. Don't drive any vehicle unless it's equipped with that device. It's a device you have to blow into to get your car started and to keep it running occasionally. That's for what's called a rolling test.
What if I choose not to drive?
And you still have to have either that or a in-home device. So there are also some ways not to have it in your vehicle, but you can work that out with pretrial services. Because you also have to go by and see pretrial services not later than close of business the first business day after you get out.
Okay.
And you gave me your initials in that lower box saying you need us to notify Mr. Jones, didn't you? Oh, all right, thank you. Haley McBride. Ms. McBride, you have one charge of assault causing bodily injury to a family member out of Aubrey. Bond on that's at $2,500. So bonds run you baby $250, $300 to get you out on that. It is bondable. It's about half the price of the normal ones because the way I read it, this could have gone either way or both.
Yeah, I didn't hit him. He hit me.
Okay, let's avoid saying anything too much. But yes, actually, to be honest, it actually said that in the report. And that's why I cut it in half pretty much. They had also put in a request for a protective order that would have kicked you out of the house, and I'm not signing that. But I'm thinking a little time apart would probably be a good idea.
I was wanting one for him though. How do I go about that?
You can contact the district attorney's office and ask them for one, and they can just do that, or you can either hire an attorney and try to do it yourself. It's an application through a family court, so. At any rate, let's try to get you out on this. So let me get your signature on that line, just saying you understand rights, charge, and bond. And then, do you think that you can arrange for that bond?
Yes, sir.
Initials in that top box saying you're not claiming to be indigent. So you have your own house or apartment, right?
Yes. We were just like staying the night and we had too much to drink and I told him I wasn't leaving because I had too much to drink. So he told me that he would make sure I go to jail tonight then.
I'm thinking a little less alcohol might be a good approach too. Just saying.
Yes, sir.
We talk a lot about how drugs are so horrible, and they are. They can destroy lives. But I'll be honest with you, I see more.
Alcohol is too.
I see more family violence issues from alcohol than I do anything else. So, yeah, and the report to your benefit did say that he hit you as well. So, let's see what the DA's office does with it. Okay.
Thank you, sir.
Have a seat. Dustin Akers. Mr. Akers, one charge of failure to comply with registration requirements. It's a Denton PD warrant, DPD 21-5306. Looks like it was issued out on August 27th. So bond's a little bit lower than normal at $2,500. At $1,500. So bonds running maybe 150 to 250 to get you out, but it is bondable. Signature on that line, just saying you understand rights, charge, and bond, not saying you agree with it or admit guilt. And then initials, and are you going to be able to get your bond posted or hire you on Mr.
Yes, sir. Yes,
Initials,
sir.
top box, initials in the top box saying you're not claiming to be indigent. All right, thanks. Have a seat.
Oh,
Joshua Elmore. Mr. Elmore, one charge of cruelty to non-livestock animals. It's out of Fort Worth PD. Is a really strange affidavit. I assume they're saying this happened yesterday or last night.
Yes, last night.
You can see where I marked through the bond amount and actually reduced it. So it's at $5,000. Bonds running about $400 or $500. I'll be honest with you. Sometimes the press gets hold of these and the society goes crazy on this charge. So this is a low bond for that charge. $5,000. Bonds running about $500.
Okay.
Does this animal live where you live? I couldn't tell from
No
here.
longer animal control. Took it this morning before I was taken down to Tarrant County for questioning by the detective.
Post bond, get out of jail, and let's see what they do with it on this. It's going to be filed on the Denton County site, even though it's Fort Worth PD. So signature on that line and then initials in the top box if you think that you can afford to hire your own attorney, or at least for the short term, get your bond posted. Can I ask you initials in that top box saying are you gonna bond out
I'm gonna bond out. Yes.
and hire your own attorney, right?
Yes.
So initials in the top box, if you didn't already do that for me. Can I ask you who called the police and how did they get videos of this?
The neighbor who lives across the street from my apartment has a Ring camera, and Ring cameras aren't active until they sense motion. And because of the close proximity of the doors, whenever I leave my apartment, their Ring camera activates, which is why they were able to, I assume, acquire the video.
Well, that didn't help.
No.
All right, so hopefully we don't get any blowback. Believe it or not, for this charge, that's actually a low bond. As I said, sometimes the papers pick up on this and it becomes a big deal. So just ask Michael Bick. All right, have a seat.
All right, thank you, sir.
I don't think he knows who Michael Bick is. Olivia Todd. Ms. Todd, this one charge of assault causing bodily injury to a family member. Your bond is also half of what it normally is. And the reason is because your husband did not want you arrested. He told him he didn't want to file charges and he refused to participate. But that kind of underscores this point. It's up to the state to decide what to file. So they could still take the case with or without him. I'm also not doing a protective order because he obviously didn't want one either. So you're free to go home. Y'all need to try to be a little kinder to each other, right?
Like sis said, the alcohol and
Yeah, I picked up on that. I
yeah.
picked up on that theme there too. Yep. So let me get your signature on that line saying you understand rights, charge, and bond. And then initials in the top box if you're going to bond out. That's quite a shirt to wear to jail too, by the way.
No, this was a bad choice. They picked me up and this was what I had on. I'm
The change on my mood swing just snapped. Okay, well, no evidence necessary here. Why don't you have a seat?
turn it inside out before I walk there.
Maybe not worried at all, at least not when you're expecting the police to show up. Anthony Walker.
Sure.
Mr. Walker, one charge out of the Colony PD. Actually, this is not a new case. This is a matter of the state law changed on January 1st, and now it requires that I meet with people not once, but twice to go make sure they understand conditions of bond. You have been released on a PR bond of $50,000. So that means you're not paying any money on that. It just means that you have to put down a good address where you get your notices and make sure you show up. Just because it's a personal bond and you're not paying money doesn't mean you don't have to come back to court. You do if the case gets filed, but right now it still hasn't been filed, so you're released on a personal bond, but there are conditions of bond.
Yes.
And those conditions are fairly onerous. It does say that you need to check in with or register with Denton County Pretrial Services. So you need to go by and see them by close of business, first business day after you get out. First of all, let me go ahead and Angela, if you could reprint the magistration sheet, because I wrote on there the personal bond and that wasn't on that sheet there.
Sir, for me to sign is going to be kind of difficult. I have, I think it's Parkinson's. I fell from a roof years ago, 50 feet.
Okay.
So it's hard for me to write my signature. So I have to like do a scratch.
That's fine. Whatever your mark usually would be, that's fine as well.
Okay.
So let me have her reprint this and then you can give us your signature or mark and we can get that taken care of too.
Thank you, sir.
Now, while she's printing that, again, these conditions of bond require that you do certain things. You have to register with Denton County Pretrial Services by close of business, first business day after you get out. So if you get out today, not later than 4 o'clock tomorrow, you need to go by and see them and register with them. You do have to stay within Denton County, Dallas County, Tarrant County, or any county to contiguous thereto. In other words, if you want to travel, you'll have to get some permission through pretrial services. Can't be in possession of a firearm. Must make your court appearances every day that you're required to. So they'll notify you. Make sure on this personal bond that you fill out that you put down a good, solid address where you know you'll get your mail. Okay.
Excuse me?
Make sure you put on your personal bond a good address where you know you'll get mail. Okay.
Okay. Yes. Yes, sir.
There is a requirement that you have a ankle monitor. You can have your attorney. You must have court appointed counsel because you got a personal bond. Talk to your attorney. I'm willing to waive that if he files a motion, state agrees, but it says within 72 hours of release from custody, you have to check with Denton County Pretrial Services and get the ankle monitor, which is a GPS device. Do not communicate or go within 1,000 feet of the victim anywhere, and certainly don't go with it at their home. So if you understand those conditions, not saying that you agree with the charge, just you understand your conditions,
Well, the thing is we live at the same place.
Not right now, you don't.
Okay, so where do I go?
I don't know. I don't have a good answer for you.
Okay, I have a place I can go to. Okay, I appreciate it.
Yeah, I think we're just trying to get you out is what we're trying to do.
Yeah, I
So
got you.
I would contact your attorney, Ed Niehaus, and discuss that with him. He's a very good attorney. He's pretty aggressive. He'll give you good advice. He's the one that filed the request to get you out of jail.
Okay,
So signature on that line, and then we'll start to process your personal bond as well. Make sure you go by and see pretrial services by tomorrow, okay?
by tomorrow. Okay, I just need the address and stuff and I can have,
It's in that sheet, and we'll give you a copy of that.
think about it.
Uh-huh.
Sir,
Oh, yeah, give me a signature on the bottom of, a signature mark on the bottom of that conditions of bond. Thomas Sinclair. Mr. Sinclair, one charge of, it's just, I think we're just trying to clear the books for you. You had that criminal trespass set by Louisville PD at $2,500. You still have to post that bond. I don't have anything to do with that, but they also came up with a failure to pay toll, a KPS Pro fine out of JP Precinct 2 from 2019, warrant T19-2571J1, J2, I'm sorry. Has a cash fine amount due at $269, but what I'm going to propose we do is just get you credit for the time you've been here so we can wipe that one out. Okay. So let me get your signature on that arraignment sheet, just saying we talked about your, you really don't have any of those rights on this charge since it is a fine that's due. And initials in that bottom box right above your signature say, I'm sorry, initials in the top box because you're not entitled to a court-appointed attorney on this case. But then there's
which box?
the top one since he's not entitled to a court-appointed counsel. And then let me get your signature on that form, just saying that you understand that you're asking for full jail credit. I'm giving you full jail credit and making that recommendation to the court. Okay.
Yep.
All right. Thank you.
Judge, is there any way that I could get you to lower the bond on the criminal trespass? My family just can't make it, to be honest with you.
Well, it was set by Judge Holman. I think the other problem is under some of these new guidelines that kicked in place on January 1st, your prior history is preventing you from doing it, but your attorney can ask for a reduction in bond. Okay. All right. Thank you. Robert Johnson. Mr. Johnson, one charge of second-degree battery out of East Baton Rouge Parish in Louisiana. Not a new case; it's an old case, but one that I'm just going to see if you want to ask Baton Rouge, Louisiana, to come pick you up a little bit faster. We can't take care of this case for you here, but it looks like you are bonded out on everything that's in Texas. You have a Collin County and 2 Denton County. You posted bond on those. So now the next question is, you have this one out of Louisiana. You can fight extradition. You have a right to an extradition hearing. That's really what we're talking about here today, is whether or not you want to ask to be set up for a district court to determine whether or not you should be transported back, or whether or not we'll allow Louisiana to come pick you up. If you do that, it could take us up to 3 months to get that set up. And during that period of time, typically that time does not apply to your Louisiana charges. But if you want to do that, we can get you set up, but it will kind of slow the process down. Or, and the alternative, you want to waive that hearing, you can ask us to notify Louisiana to come pick you up. We typically give them only 10 days to come pick you up. If they come pick you up, then you can take care of your case with them in Louisiana. But you do have a right to fight that removal and to demand a formal governor's warrant of extradition or executive order to have you removed. You can challenge the sufficiency of the documents, and you could also challenge they don't have the right person. But other than that, you don't have the right to have the trial. We actually don't even have that exact same charge. We don't have a second-degree battery charge here in Texas. And if you're asking for a extradition hearing, we'll also try to get you a court-appointed attorney. But again, only for the purpose of decide whether or not you should be removed from Texas. So with that in mind, do you want us to set you up for a hearing that could take us up to 3 months to get that set up, or do you want to ask, do you want us to notify Louisiana to come pick you up?
It's all right, so basically me waiving my right. So that's just gonna get the process started today.
That's right.
And so they gotta come get me.
Yeah, and we typically only give them 10 days. Now, Texas is we're longer than that, but unless they give us a very good reason why they can't be here, it's not that we don't love you. We just don't want to house and feed you.
It's all good. I
So,
appreciate y'all.
so if they don't come get you in 10 days, we typically call them one more time and say, are you coming or not?
All right.
Unless they don't give us good reason, then we kick you out. Now, if we let you go, they'll just reissue their warrant. Louisiana is pretty aggressive about their warrants too, by the way.
Oh, I understand.
Okay, so let me get your signature on there saying we talked about your rights and you're not asking for an extradition hearing. You want us to notify Louisiana to come get you. And then your initials, actually, and then there's a second page, and that's a formal document that's going to be dated today that will start the 10-day period of time. So did you sign both pieces of paper?
What you say this one for?
One is just that one is that I'm telling you about your rights, and the other one's the actual formal waiver that we send to Louisiana. They're kind of the same thing, just one's like, I'm telling you have that right, and the other one's going, I know, I don't want it. All right, we'll let Louisiana know, okay?
So the day start now?
Yeah, it would start now. Leotis Rogers. Well, Leotis, what a night. So it looks like it was the Prosper Police Department had a charge of evading arrest. Oh, I thought you escaped. Charge of evading arrest or detention by use of a vehicle, which is a felony grade offense. So it has a bond at $10,000. That's from running from the police while in the vehicle. Charge of resisting arrest, search or transportation, although it wasn't the most compelling case, so that one's a little bit lower bond at $2,500. One charge of possession of marijuana under 2 ounces amount at $500. One charge of possession of controlled substance, penal group 1 to 4 grams, that of cocaine at $2,500. One charge of possession of controlled substance, penal group 2, 1 to 4 grams, ecstasy at $1,500. One charge of possession of controlled substance, penal group 1, 4 to 200 grams, methamphetamine at $5,000. One charge of possession of controlled substance, penal group 1, under 1 gram, Oxycontin at $2,500. And one charge of possession of controlled substance, penal group 2, 1 to 4 grams out of Dallas County warrant F21 41954 at $5,000. So one Dallas County case at $5,000. And then, let's see, $7,500, 9,000, 11,500, 12, 14,500. So $24,500 to Denton County, $5,000 Dallas County. Now there's another one. They charge you with another offense of manufactured delivery controlled substance, penal group 1 to 4 grams. I'm not sure where that came from. I went through very carefully, looked at all their affidavits, and I'm not sure where that came from. So I'm finding no probable cause and dropping that one. That is a much higher charge since it's a manufactured delivery. I assume what they're trying to do is claim because the cocaine was over a certain weight that it was packaged for distribution. They can take that up later. No, it'd be best if you don't explain it, because I'm just going to drop it for the time being. But I'm just telling you, they could come back and get a different warrant from somebody else. So at any rate, so if you understand all your rights, not saying you agree with it or admit guilt, just you understand your rights, your charges, and your bond. Let me get your signature on both pages saying you understand rights, charge, and bond. So a bondsman will probably run you about $3,000, maybe $3,500 to get you out. Do you think there's any possibility that you're going to be able to hire your own attorney or post your bonds?
I got my wife and my sister on it, so they're doing whatever they can.
You're doing better than I am. So let me get your initials in the top box there saying you're not claiming to be indigent, that you're going to get your own attorney. You're not asking for a court-appointed counsel either from us or Dallas County.
Okay.
Initials in the top box on both of those pages.
Your Honor, I think it's confused on the indigent and not indigent.
Okay, are you going to be able to hire your own attorney and post your bonds?
I asked for a court appointed attorney. I don't really know if I'm gonna be able to post a bond or not, but I asked for a court appointed attorney.
Are you working anywhere?
Yes, sir.
Where do you work?
I work at Sophia's Bar and Grill.
If you want to put your initials in the bottom box, you can do that. I'm not sure about how much per month do you bring home?
About 1,800.
Yeah, I don't think you're classically indigent, but I tell you what you could do is if you bond out, you can still come back and ask for court appointed counsel, or you can fill out an application now, but I don't know that they find you indigent, but you can give me your initials in the bottom box if you claim to be indigent. Indigent really means that you're living on the streets, is what that really means.
Oh, okay.
I mean, but if you want to put an application, you can certainly do that. And then, as I said, they may try to go to a different judge and get a warrant on that more serious felony charge. I'm just not sure. I mean, that's like a veritable CVS on wheels, dude. So at any rate, have a seat and let's see if we can get you out on bond. Is that everyone in here?
You just gotta go down there and do that.
Oh, that's right. So that's everyone who's in here though, right?
Yes, sir.
All right, folks, go call, see what you can do to get your bonds posted. Bondsmen love credit cards and debit cards, so hopefully you can work that out with them.
Can I ask one more question?
You just did, and you only get one more, so you used it up.
Hey, excuse me, sir. So they actually arrested me in Irving yesterday and brought me over here. But they took 1,800 from me in a cell phone. They said they was gonna bring it back, but I just talked to the people up here in booking, and they said that they can't accept money or any other property after I'm already booked in.
What agency arrested you? Kent County SO? Oh, what's your last name again?
More, M-O-R-E.
I'm looking at, it's a warrant, so I don't know. They picked you up in Irving? Oh, so in other words, Irving had you arrested, but you had cash on you, right?
Yes, sir.
And so who has the money now?
I can't even tell you who, Irving should have it. But I couldn't even tell you what the officer name was. It was so many different officers I was talking to last night.
Yeah, it looks like the county sheriff's office sent someone down to pick you up. And do you think that they're trying to seize your money to?
No. They told me they were gonna give me my money back. Actually, I didn't. The county sheriff's office didn't come to get me. I met them in Buc-ee's. I've never had a transaction like that. Like,
Let's stay away from that one. Try to get your bond posted, then you can come back and say who has your money. I don't have any good answers for you. Right? Okay. All right. Stay away from those transactions. Well,
I'm Walker. I'm not allowed to go back to the house.
no,
Okay. I appreciate it. Thanks.
sure.
Judge, have you finished signing the ones for Carrollton?
I'm signed one of them. I haven't signed the other one. But I'm working on it now.
So I was gonna say, you wanna just send them this link or what?
That's fine. If you want to, that's fine.
I think it might be less confusing than yesterday.
No, actually, if they had now I'm confused on it. So did we send them a new link?
Christine is back, so we'll just get with her to see if she can get it all set up for you.
Okay. All right.
Just let me know whenever you're done, and then I'll do what I gotta do with them.
Okay.
You want me to do them again?
Well, no, but No, I guess because she has some lined up for you to see down in the open holding, if you want to go ahead and start to take care of those. Can she go ahead and do those, Angela? Because you need to take a break and go.
Yeah, you already have signed them all, so everything is ready to go. So, okay,
Okay,
I'll just add this to the afternoon arraignment since that's where I put them. Is that all right?
yes, that's fine.
Okay, these three right here, they have been exposed to COVID, and so they kept them down there. And they didn't tell me until after the judge had signed everything and did everything what he needed to do to them.
I'd forgotten I had my signature's on each one of those, right?
Yes, sir.
Would you like to go get your mask? Oh, I have one. Thank you. Oh, here, I'll put it on. Sorry.
No, she said to go down there
Oh, yes.
to talk to
Yes.
them.
I'm good. Thank you,
I
though.
have 100 if you want to. Just don't let them open that beanhole.
They do. That's the only way I can talk to him. I had to talk to him through the beanhole.
No, talk to them through, you put your ear to that crack.
Ask you, what's
They've
your,
been exposed to COVID, so you don't want the top and come out on you, but I'm.
What's your- Judge ask you, since I filled out all the paperwork, do you want to use those or you want to redo some, or you just want me to go down and finish those that we fill out with my name?
I can go and tell them what you did unless you think that's problematic.
No, I want to give you your deference when it's, but for today, let's just go ahead and use those, and then in the future, I'll see if we can work around that. So yes, if you can, and if you feel okay with that, then let's go ahead and do it that way.
Wait, I'm gonna question what you did. That's funny.
Well, you have some, you magistrate in your own right, so. Okay, that's good.
All right, thank you. Can I get to tell them about an extradition hearing?
Oh, wait a minute, is that one on here?
Cedric McLaughlin has extradition.
Oh, that's why, Judge.
And that's one that I'll have to take care of later.
Okay,
Yeah.
alrighty, then I'll give that one back to you.
Oh, yeah, that's the one. That's supposed to. Oh, is she over there? Well, you know how we need her over there? We gotta need her help with this girl thing. She's on the phone with Tiffany. Yeah, I told her. Okay, that's why she didn't answer. I will tell her. Tell her I said thank you.
This one Judge said with an EPO, but the EPO is not in here.
Oh, you know what? What is this in the block?
This is for Hayden Clark.
Oh, I meant to do one up because we did not have the pink sheet in there, but I had the PC affidavit that has her name and address in there.
Date of birth. So we can do the order itself, but for the data sheet, we don't have to. break that.
No, I need the whole thing. I have to look and see if this is the one.
There's only these two for this afternoon that I can do that?
And I haven't, we just got through with the
Oh,
morning, I have
okay,
not
okay.
written back the others yet.
All right.
These were just on the morning and I had to put, okay, this is the one. No, this is not that one. You wanted me to issue an EPO for this person?
Yeah, if we could.
No. I'll have to get you.
PC affidavit, there's some information in the PC affidavit.
I have to issue one, so we'll have to hold out, we'll do this one later, after the other one.
Okay, all right. Well, I could go ahead and go take care of this one and give you time to work on that stuff.
Okay, so yeah, then we're going to get his, yeah. Getting ready to do care.
Do you not get a chance to get anything to eat?
No, I brought my stuff, but I'm so used to it, it don't even bother me. Thank you.
I'm through with the Carrollton stuff.
Right.
So do we know how I'm gonna log in on this thing?
No, let me see if I can reach Christine. Amy, can you tell us how we're gonna be able to log in, or since Judge is already up in here now, can I just invite them to this link that he has, or do we need to send them a new one?
Will you guys go in the one on the calendar so they don't get confused?
Okay,
Yeah, that'd probably be best, just so we don't confuse them.
Judge,